All right, welcome back. Today we're diving into a story that shows just how a seemingly simple neighborhood fight, I'm talking about a gate code, can spiral into a full-on legal battle that goes before an administrative law judge. It's a wild ride about rules, rights, and how one tiny detail can change absolutely everything.
So let's just get right to the heart of it. Can your homeowners association stop you from having your very own personal gate code? I mean, is that even legal? Well, that is the exact question at the center of this story. It's a classic showdown, one homeowner versus her HOA.
So our story really kicks off on July 28, 2021. That's the day a homeowner named Kathy Padalino officially filed a dispute against her HOA Legend Trail Parcel A. And let me tell you, she was convinced they were dead wrong, and she was ready to fight for what she thought was hers.
I mean, she did not mince words. Right there in her official complaint, she laid it all out. She said that by refusing her a gate code, the HOA was violating the community's own rules and her fundamental rights as an owner. For her, this was way more than just an inconvenience. It was a matter of principle.
And just like that, the battle lines were drawn. On one side, you have Ms. Padalino saying, "Hey, I'm an owner. I deserve my own code." And on the other, you have the HOA firing back. "Look, we've already given the property all the access it needs. This one single point of conflict? Yeah, that's what this entire case is about."
So, let's dig into Ms. Padalino's side of the story. Because, you can't just go to court with a feeling. You need to be able to point to the actual rulebook, the HOA's own playbook, and show exactly where they messed up.
And she thought she found her smoking gun. She pointed to this section right here. Her logic was all about that little s at the end of owners and residents. To her, that plural meant access was for all owners, individually, and that she should get her own personal way in.
Now, let's be really clear here. It's not like she was literally locked out of her own neighborhood. The real issue for her, the core of her entire argument, was about convenience and control. She wanted a 24/7 code that was hers, one she could give out to friends and family whenever she wanted.
Okay, so that's her side. Now let's flip the coin and look at the HOA's rebuttal. And folks, this is where the story takes a massive, unexpected turn that honestly changes everything. So remember, her whole case is built on this idea that she's being denied access, right? Well, the HOA's response revealed let's just say a pretty major flaw in that logic.
And that flaw, it all comes down to one simple number: 4. This is the number of ways Ms. Padalino could already get into her own community.
Yeah, you heard that right. As it turns out, she had a remote fob for her car, the 4-digit code that was already assigned to her property, a separate vendor code for service people, and a working gate opener. So this idea that she was being denied access, well, the evidence showed she had plenty of it. But, okay, hold on. That's not even the craziest part. The real bombshell, the biggest twist in this whole case, is that the reason she couldn't just hand out the main gate code had absolutely nothing to do with the HOA. The restriction was coming from somewhere else entirely.
And there it is, straight from the judge's findings. It turns out her co-owner, a Mr. Van Scribble, was the one who asked her not to share their property's single access code. Her fight wasn't really with the HOA at all. It was a personal disagreement with the other person on the title to her home. So with that major curveball thrown into the mix, the judge had to turn to the official documents. Forget the personal drama for a second. What did the community's gate policy actually literally say? And, you can kind of see where she might have gotten the idea. There was an older rule from way back in 2006 that said each household may be issued 2 unique codes. That wording probably fueled her belief that she was entitled to a second, personal one. But here's the thing. That rule was ancient history. A brand new policy had just taken effect in 2021, and its language was crystal clear. Each lot will be issued a single 4-digit code. One lot, one code. End of story. This was the rule that mattered now, and it completely shot down her claim. So you've got the homeowner's claim about convenience, the HOA proving she had plenty of access, that stunning twist about the co-owner, and the clear-as-day wording of the current rules. All the pieces were on the table, and it was time for the judge to make the final call. But before we get to the verdict, you got to understand the legal hurdles she had to clear. It's called preponderance of the evidence. It sounds complicated, but it's pretty simple. It just means she had to convince the judge that her side of the story was more likely true than not, even by just a tiny bit, like 51 to 49%. So what did the judge decide? 2 words. Petition dismissed. The homeowner lost her case.
So why'd she lose? Well, it pretty much boiled down to 2 huge things. First, she couldn't prove the HOA actually broke any rules. In fact, they were doing exactly what their policy said to do, one code per lot. And second, her real problem wasn't even with the HOA to begin with. It was a personal issue with her co-owner. She was aiming her fight at the wrong people.
Okay, so what's the bigger picture here? What can we all learn from this very specific, very personal, and kind of dramatic fight over a 4-digit number?
Well, the first big lesson is that those HOA governing documents, they aren't just suggestions. They have real legal teeth. A clearly written rule, like one code per lot, is incredibly hard to beat in court. It's a huge reminder for homeowners to read the fine print, and for HOA boards, it shows just how powerful, clear, simple rules can be.
And the other giant takeaway is this: you have to know who your fight is actually with. This case is the perfect example of how you can't force an HOA to solve a personal beef between two people who own a home together. All the time, all the money, all the energy spent on this was basically wasted because it was pointed at the one group who had no power to fix the real problem.
Which leaves us with one final question to chew on. This whole thing really boiled down to one person's desire for convenience bumping up against a rule setup for the whole community. So when those two things clash, who do you think should get the final say?